We're going to talk about legal issues. And the first thing I have to say is to turn this on, right? This is for background. It's not real legal advice, because real legal advice involves specific facts, and what I say today could change tomorrow if the law changes. And a lot of the stuff I'm going to talk about has a lot of technical detail underneath. I'm going to try to bring it up to a level of what do you need to know as an entrepreneur. So I may be simplifying a few things. So at the end of the day, don't try to be a brain surgeon and do it yourself brain surgery. Try to say, oh, I think there was an issue there that Joe talked about when you encounter it, and be smart enough to go ask somebody. That's the goal here. Okay? So we're going to talk about this in different stages of the company. Or the pre-company. We have the idea stage, and then there's the pre-financing stage, outside financing, the initial outside financing, Series A and later financings. And we're going to talk about intellectual property. We're going to talk about the legal entity. We'll talk about a number of people issues. And then finally, financing. Try to put it in some context as you might encounter these things. So on the idea stage, the first big issue is who owns the ideas, right? And that could be anything from your current employer, if you're employed. It could be MIT, a coworker, or else. So let's dig into that a little bit. And then in the pre-outside financing, how do you protect the IP? So let's talk a little bit about how IP can help your venture. First of all, it's a valuable asset. A lot of venture capitalists will want to know, do you have some sort of IP, and what is it? What is your strategy for protecting? We talked about Keurig the other night. How come there weren't more people with the cups? Well, it's because they had patented that space pretty well. And if you tried to go into that space without knowing it, you might have a hard time. There's correlation with success. The company that I co-founded and I'm running, IP Vision, did a study. We were a venture partner in a late-stage venture fund using analytics of patents as a way to screen and rate investment opportunities. And we did this on some 10,000 venture-backed companies. And what we found out is there was a high correlation between how people scored on our IP score and success. That is, people that were in the top quartile of the rankings we did, which was based totally on public data, tended to be winners. That is, they had gone public or had been acquired. And it was like 6 out of 7 that got our top ratings were in that group. So there is correlation with that. The study I put on the website under the Nuts and Bolts website under course materials if you want to download that. And then finally, learning to manage your IP says something about you to investors. As I said, investors are looking at the team. Is the team, why this, why now, why this team? And if you've got a good IP strategy and you're executing on it, that gives them confidence that the team is good. By the way, the correlation with success, it's correlation, it's not causation. And it may very well be that in areas where technology is important, the people that managed IP well managed the rest of their business well. And that's a hypothesis, hard to test. Okay, so what kind of IP is there out there? Well, first, there's none. There's trade secret. And if trade secret, by definition, if nobody else knows it, nobody else can use it. There are trademark and copyright. These generally enhance value, but they don't block anything. We're going to go into each of these categories. And then there's patents, which cut both ways, because to get a patent, you have to disclose what you're doing. And once you disclosed it, you've sort of let it out of the bag, and it's how much do you have it protected? So it cuts both ways. From a cost viewpoint, a duration viewpoint, patents have the lowest duration, 20 years from the date of filing in the US, and trade secrets could last forever. And inversely, the cost goes the other way. The patents are the most expensive thing. So you have to do these trade-offs between these. And some things can have multiple protections, like software could be protected partly by patents and partly by copyright. Okay. So starting off, a trademark. Okay, and people always get this difference. They'll use the term trademark when they mean copyright and vice versa. So trademark is very simple. Trademark means a mark, something that goes with your product. A service mark is something that goes with your service. And what it is it can be anything. It could be text, a symbol. What's a good symbol that you think of as a trademark? An apple, okay. Or the swoosh, okay. What about a color? People have actually colored, trademarked color. What's that?
The magenta from Deutsche Telekom?
I don't know if that one is, the magenta, but that would be an example. Well, the one that I know has been trademarked is the color pink. And can you guess what pink has been trademarked for?
Breast cancer.
It could be. That's an interesting thing. The one that I know about is for a building insulation. Owens Corning pink insulation. And when people see it, they think of Owens Corning. Now, your point about whether it could be for the breast awareness thing illustrates the other thing. A trademark is what associates the source of the goods or services in the mind of the relevant consumer. So you could have pink trademark for building insulation. You could have it for breast awareness type things. They can have the same thing in two different areas. And sound. What sound do you think might have been trademarked? I gave you a hint in the next line. Anybody drive a motorcycle? Anyone had a motorcycle pull up next to them? Anyone ever heard what a Harley sounds like? Is it a distinctive growl? Yeah, so that's actually trademark. So if you put out a motorcycle that has a sound like a Harley, and you're not Harley, then they could get you for trademark infringement. I put on the website a YouTube video put out by the lawyers from the Velcro product. It's sort of a hilarious thing to think that lawyers could do a rap video, but it's a little bit entertaining, and it shows you a little bit about how they don't want you to use the term Velcro to refer to anything but Velcro brand fasteners. So the use of a trademark, the way you think of a trademark is if you put the trademark in a sentence as an adjective, Velcro brand fastener, Owens Corning, brand insulation, something like that. You don't want it to be used as a verb. So when you say, I will Xerox that, then that's how you end up losing a trademark, because it becomes generic. So if you get a trademark, you actually have to enforce it if people start to use it in ways like that. So take a look at the Velcro one and have a fun time with that one. The trademark arises from use in commerce. You don't have to register anything. You start talking about your product or service and you use a name or something with it. Typically, if you do that and you want to claim a trademark, you put a little TM or SM if it's a service mark. So if you have a branded service. You can go and register that federally for not a whole lot of money. And if you do get the registration, you get to put the R in the circle. So don't put the R in the circle until you've actually got it registered. And when you have registration, it gives you certain rights across the whole country and things we can go into separately. So again, in the case of people talk about well, let's talk about a type of mark. You should try to use a fanciful mark. So Apple for computers, right? If you use something that's merely descriptive, you may not get the mark. So I tried to register a mark once, the mark microdose, for low dosage aspirin, because it was shown that if you take a low dosage aspirin, it reduces the chance of heart attack. And I had a long discussion with the trademark office over, well, microdose is merely descriptive of the thing you're selling. It's a small dose. Or analog devices, they're selling analog devices. So the more fanciful you are, the broader the protection you can get. So if I went to try to set up Apple or a pharmacy with the name iPharmacy, I bet you Apple will come after me because they have so many different I brands. And so the more fanciful kind of thing, the better it is from that perspective. Now, sometimes you can check to see if the mark's available. Search right on the website at the U.S. Patent and Trademark Office, and you'll see what's available for that. Now, does anyone know who owns Tide brand laundry detergent? I think it is, but do you care? Right? So a lot of people spend their time worrying about what their company name should be. And really, to protect a company name across 50 states can be more expensive than you'd think. And if I had more time, I'll tell you a nice anecdote about that. What I recommend people do is pick a name for what you're doing, the product, because that can be easily. So you could have Tide in Joe's product company, and Joe can sell Tide to Procter & Gamble, and it's still Tide. The consumer, the value in the brand is in the name Tide. It's not in the name of the company that makes it. So that's one thing to think about if you have something where you think trademark would work. Any questions about trademarks before I move on? Okay. They last, there was one other thing. I said it had to be used in commerce. And 10, 15 years ago, you'd actually have to go put a product and ship it across state lines in order to then file it. And recognizing when you launch a product, you may have a lot of advertising and marketing materials and everything. You don't want to launch it and then find out you're going to have a problem. So they do have a thing called intent to use, where you say, I intend to use this mark for these goods. And once you get approved for that, then you get the registered mark when you actually use it. You have a window in which you can use it. So this way you can know that the patent office has okayed your mark without having you spending a lot of money to actually put something on a product and ship it across lines. Okay. Oh, good point, international. All of the things I'm talking about here there's no such thing as international marks or international IP. It's country by country. What I'll be talking about here is the US. But if you get a mark in the US, a classic problem is if you go and you try to do a distribution, get a distributor, say, in Italy, and that distributor goes ahead and registers a mark in Italy, your mark, you don't own it, the distributor owns it. So if it gets expensive to do that. So it's like anything, you make a business decision on where am I going to sell product, how much money am I going to spend on it. But it's country by country. Okay? Copyright. Copy is the right to make copies. It protects copies. In other words, if I put something out there and you literally see it and copy it, you've infringed my copyright. Just like a trademark, you don't have to register it. If I write a letter to my mother, that's a copy. I have a copyright in that automatically. It's an original work of authorship. I get benefits if I do register it, but I don't have to. Now, what it does is, if you have one person on one side of the country writing a novel, and another one on the other side of the country writing a novel, and it's the exact same novel, and they've never looked at each other's work, that's not infringement. It's the copying of it. And the reason is, if we allowed people to totally own an entire work of authorship and prevent others, then it gets a little tricky. If you think of the standard thing in literature, love triangle. If Shakespeare could have copyrighted that, then there couldn't be any other love triangle things in the world. So it's about specific things. It can be very useful for things like music, but maybe not so good for for software. It protects the expression of an idea. It doesn't protect the idea itself. Does that make sense? Okay. I once represented a map company, and they invest a lot of time and money in making accurate maps. And to protect themselves against copying, they would put a street on a map where a street didn't exist. So if you've ever used a map, I don't know if they've done this with the Google Maps type thing, but in the old days, if you opened a map up and you said there should be a street here, and there wasn't, it was probably something that had been put in there to demonstrate if somebody had another map with exactly that street, that they must have copied it. Things like, and in computer code, people would put non-functional code in there. So if somebody took the code and said, well, why is this stuff in here? It doesn't actually do anything. That would be another way to show that something had been copied. Now, the question is, who owns the copyright? Well, when you do an original work of authorship, which can include software, that took a number of years before that simple statement could be said, by the way. The lawyers went for years about whether software was copyrightable. It's owned by the author, unless it's written by an employee in the course of employment. So if you hire someone as an employee and they write software for you, and you're hiring them to write software, you will own that as the employer. Now, it gets interesting for startups because often we don't start with employees. One of the companies I'm involved with, we don't have a single employee yet because we're using consultants in regulatory affairs and circuit consultants and things. Eventually, we'll have employees. And so if we don't do anything, if we didn't get them to sign agreements, guess who owns all of that work? Right? It's the author. So the independent consultant owns it, unless you get an agreement saying this is a work for hire and I agree to assign it to you. Now, if you're an independent consultant, if you program for people and you deal with large companies, you're going to get presented with this consultant agreement, and in there it says anything you do will be owned by the big company. And you have to go through the song and dance, especially in the software area, saying, well, you can own the specific implementation of what I'm writing for you, but all of the modules and stuff that I've worked before, those are my tools. And I have the right to take them and build something for someone else. And so if you go down that route, plan to go back and forth with the legal department a few times. But it's more important for you as an entrepreneur, if you're using people that are not employees, to make sure that you have the rights nailed down. Because when the investors come in and they start to look at it and they find out you don't have the rights, you're going to have a problem. You may not get funded. So is that clear? Questions on that? Good.
Joe, will you talk about, under founder agreement, when individuals who've built independent things combine together, who owns what?
That's called an original work. It's a derivative work. So, yeah, in the copyright area, let's say everyone in this room had written a poem, and I decide I'm going to put together and publish a book called The Poems of Nuts and Bolts. Well, you have copyrights in each of your poems, and if I get permission from you, I have a copyright in the derivative work, the combination of the anthology of those. And so by analogy, if you have people writing bits and pieces, it'd be the same thing. So if one person's doing, maybe the user interface and the other one's using the back-end server and they come together, the individuals will own it, and then the combination would be owned jointly, most likely. But you don't want to take that to chance. You want to have it written down clearly, as in most things with law, the clearer it is. Also check the open source issue. If you can use code, open source code, but under the general licenses, if you modify it, you're supposed to contribute it back. And so if you're modifying the core of that code and trying to take a product to market, that's going to be a problem. So one way to avoid that is you use MySQL as a database, write your interface separately, but don't mix the two together. But if you're in software, make sure you look at the open source issues. In fact, there's a whole company, I think Black Duck, used to have something that would just look through code to say how much open source code was in this and would it violate. Okay, let's go. Copyright. How hard is it to get copyright? Not hard at all. You have to file a copy of the work, which for software was a problem because if you actually gave the source code out. So for software, there's a procedure to redact or mark out the source code so that people can't look at it and reverse engineer it. The theory is to show that it's copyrighted, you have to say against what. So the registration federally with the Library of Congress is there's a copy here that has been registered and somebody can use that to check, sort of like the national standard on that. And it lasts essentially longer than you need to worry about. It's like 75 years. For anything we do here, it's irrelevant. If you're Disney and you're worried about rights to Fantasia maybe elapsing, it gets into something else. Okay. Yeah, question up there.
Yeah, just a question. For copywriting as it pertains to contracts, as you just mentioned, is there a go-to resource that you use for standard templates for that?
For the consultant agreement?
Yeah.
For a contract that would then list the sort of the right copywriting language that one would want to use.
Yeah, there would be an independent contractor agreement. I'm going to mention it later. There are some things. One of them is Cooley, the law firm Cooley, has a set of forms that you can you sort of fill out some things and they generate basic forms for you. I think Goodwin Procter has something. And Wilson Sonsini, I'll have in the materials, there's a link to some of those. They're pretty good, but everything's sort of fact dependent. So they'll say, this works, but we're not standing behind it because we don't know how you're going to use it. But they are decent forms. So, okay, trade secret. This is something that gives you an advantage in the market, and nobody else knows it. And what's the most famous trade secret? Is it Coca-Cola? Apparently nobody's been able to, it's always a challenge. Could MIT reverse engineer Coca-Cola, the formula, the secret formula? I don't know, is any chemists here to, would seem to be, I don't know why you can't do that. But the point is, it's supposedly secret, it's not known. And so, it does vary state to state. Usually you protect it through non-disclosure agreements. And non-disclosure agreements follow a sort of a standard pattern of, if I tell you something, you'll keep it secret. If it's, and it has a list of things that, what you want to do if you're entering into those agreements is you want to make sure that anything you agree to is in writing, that you're handed that says confidential or something on it so you know what it is you're supposed to keep secret. I don't like agreements that say, oh, anything we talk about is secret. Well, normally if it's important, then after a meeting, someone writes up a memo of the meeting saying, here's what we talked about that was secret. If you have trade secrets that are key to your, like anything, in your pitch or business plan, it's not about revealing how you do it. It's what Bob said. What is the benefit that your service or product gives to someone? That's what they're buying. And in the due diligence for the investors, that at that point, maybe they might have an independent group look at something. Because investors are worried when something, if AI just comes out and I see your deal and I pass on it and you claim and I invest in your deal, and then the question is, did I steal your idea? We just did a project for a corporate venture fund that was thinking of investing in a 3D printing company for a particular application. And part of the business, the business side there of the 3D company is they were going to license, it was big manufacturing things. And so the IP was important. And the corporate venture fund did not want to invest without having someone look at the IP, but they didn't want to look at it themselves because they didn't want to be tainted by it. So they asked us to go look at it and give an opinion, which at one level was great. They paid us a whole bunch of money, and I could have just flipped a coin because all they wanted to know, did I think this was good or bad? So that's one way to insulate yourself about, did I learn something I wasn't supposed to learn about? And if you have that issue in a due diligence, say with a venture fund that won't sign a non-disclosure agreement, you might suggest, why don't you have an independent party look at it who will sign a non-disclosure agreement with me as an entrepreneur to evaluate whatever the technical aspects are. Okay? Because most venture funds will not sign non-disclosure agreements. Okay, so the big one, patents. This is the one that has potentially the biggest protection. It's the most expensive. Again, country by country. It's a federally granted right to any system or method that is due, non-obvious, and useful. Those are the standards. We'll go into that a little bit. It's very much like real estate. Some people think that patents give you a right to do what you're planning to do. And that's not technically right. It's more like real estate. If you own a piece of real estate, the fundamental right you have is to keep someone from trespassing. Right? So if you come on my land, I can, kick you off the land. That doesn't mean I can actually use my land, because I might have to go across your land to get to my land. So think of it as, let's say I invented a vessel to hold a liquid. Nobody else had ever thought of the idea of a cup. And you look at it and say, God, what a brilliant idea. But it's sort of defective, it's not complete. I think a handle on the cup would be useful because it'll make it easier to hold and if it's hot. So if you put your handle, and let's say we both got patents on that. If you put your handle on my cup, I could prevent that because you'd be infringing the patent on my cup. Similarly, if I tried to put my cup on your handle, you could keep me from doing it. So it's a right to exclude. It's not the right to use, which is a fundamental thing people don't quite get. You can prevent them from making, using, selling, or distributing the patented invention. So if I have a patent in the US, or importing, if I have a patent in the US, you can't go to China, make the product there, and bring it back into the US. You could take the thing to China, make it there, and if nobody's got a patent in China, you can sell it there. But I'm protected in the US, so you have to file protection in each country that's relevant for you. Then the claims of the patent are the key thing. It's like the fence around the property. It describes what the property is. So the claims are the key part of the patent. And it's 20 years from the date of filing. Whoops. The question is, who owns it? Just like copyright, the inventor has the right, if a patent issues in the name of the inventor or inventors. If you're working for a company as a technical person, you probably end up signing an invention disclosure and assignment agreement that says, I'm hiring you as a material scientist to work on stuff. And if you come up with an idea, you've agreed to assign it to the company. If it's co-invented, it gets into an interesting thing, because if a patent is co-owned, and you don't have an agreement to the contrary, let's say two inventors, either inventor can exploit the patent without accounting to the other, unless you have an agreement. And of course, if you don't have an agreement, then you end up in a situation where you would never be able to have an exclusive license unless both of you agree. So co-inventorship gets a little tricky there. Application determining what to patent, when to file. Jan, when he comes in on the last day, is going to talk about his specific patent strategy with respect to the Mimeo device that you saw the first night. And he was very strategic about how he thought about what to patent. And it wasn't just because it was a cool idea, it was something that he thought added value to what he was doing. And he'll explain how that worked. To figure out whether you can get a patent, you have to compare it against prior art. So remember, one of the things I said, it has to be new, non-obvious, and useful. Well, useful is usually not an issue. Amazing what things are called useful. Non-obvious means that the invention is not obvious to one of ordinary skill in the art. So it's not a little, obvious invention. The new thing means nobody else has ever invented it or disclosed it. And to show to the patent office, so the whole idea behind a patent is a monopoly. It's a limited term monopoly where for 20 years from the filing date, if you get the patent, you can prevent others from going on your property. Now, we have antitrust laws in the United States, right? We don't like monopolies. So why do we allow, as a policy matter, why would we allow someone to have a monopoly in the course of a patent? Why did the founding fathers, why is it in the Constitution? Just think about it. You're the founding fathers. Patent system, yeah. You can get back your money? Well, I don't think they were worried so much about whether you got your money back. So the idea is, well, if I had to spend a lot of money and you could just copy it, then that was it. But for you, that's important. But that wasn't the theory, yeah. To encourage innovation. And a lot of the stuff, and why is that? Oh, I got you eating there. So let me explain what it is. So in order to get the patent, you have to actually disclose what your invention is. All right? So that disclosure becomes public. And at the time when your patent expires, which is either after its full duration or if you didn't pay your renewal fees, your maintenance fees, that idea is now available out there for somebody else to use or to build on. So by encouraging the disclosure of inventions, the idea is, we build on the shoulders of giants and everyone gets better. And it's viewed to be a societal trade-off as a good thing. Limited time monopoly in order to get people to invent and disclose. And it does fulfill the issue that with a limited time monopoly, you can get your money back for having spent time. Now, because a lot of patents have been issued over the last 15, 20 years that are not really good patents, and we've had people like patent trolls. Have you heard that term? So patent, quote, trolls are people that acquire patents and then assert them against people. They're not people who actually make anything with the patents. They buy it as an asset and they sue somebody. And that's viewed to be bad. Although the point is, and I had a back and forth with the economists. They had a big article about why the patent system was broken and needed fixing. And and they had things like, well, if an inventor doesn't actually make the invention, then the patent should disappear. And it showed that they didn't understand it. The 3D printing patents have expired. It may take a long while for an invention to get to a point where it's really feasible commercially. And by the way, inventors could be great inventors, but they may not be good commercialization people. So if they can't take it to market themselves, why shouldn't they be able to sell it to somebody who does something with it? I mean, that's the counter-argument to it. And the problem is it all gets mixed up with the fact that there's some very bad patents out there, things that should never have been granted, and people are using those as threats of suits and manipulating the legal system. But the underlying concept is still there. Disclose your invention, everyone learns, and when the patent expires or is no longer in force, it can be used. So, okay, and to find out whether we call it prior art. When you go to the patent office, you have an obligation as an inventor to disclose to the examiner all of the prior art of which you're aware that's relevant to determining whether your idea is new, is novel. And if you fail to disclose something you know, and even if the examiner would have allowed your patent in light of the prior art that you cite, it can be invalidated in litigation because it's deemed to be a fraud on the patent office. So finding out what the prior art is out there is important. You can do that with keyword searches. The company we set up, IP Vision, actually does patent maps. So for example, this one in the middle is the MEMS accelerometer chip, the monolithic accelerometer by Analog Devices. That was the first thing that was for airbags. And that's a little thing in the middle, and the fans off of those are the patents that are citing those. In other words, in the course of examination, all the ones to the right, time goes left to right, all those patents cited the Analog Devices patent. So by looking at these maps quickly, you can just see who's doing what, and you can actually uncover, how one invention leads to another. You can go and register for free at seetheforest.com. And if you're in the MIT community and you want to get the premium version, as you're launching your venture, just send me an email with the email address you used to register, and we upgrade you for free, so you can use it. So these slides, by the way, I think are on the website. So this was Yonald. He's going to talk on the last night. This was his first patent, right there. And he cited all this other stuff as prior art. And these were the people that he was citing that owned the patents. And a few years later, here are all the patents that were citing him. So he could use this to figure out, people that are citing me, could they possibly be infringing my invention? Or maybe these are potential, collaborators or people that might be acquirers. And so there's a lot of business intelligence you can glean from that. So he'll tell you about that. Here's what his portfolio looked like whenever I did this map. Okay, another important thing is, well, when do you file? So in every other country in the world except the United States, if you make an enabling disclosure of your invention before filing an application, you lose the right to apply for a patent. In the US, you get 1 year from the time you first disclose it in order to put an application in. I mean, you can file it first. And that could work for you. We're going to talk about provisional patent applications in a moment. But in every other country of the world, if you disclose an enabling disclosure before you file, you're dead. So I was mentoring some teams in a competition in Istanbul, and I was talking to a team from Egypt, and they had some great wireless technology that would increase the throughput of wireless networks 5 times or something. And they were all excited about it, and I said, well, have you published any papers? Oh, yes, we published this and that. And I went, ooh, did you file a patent application? Oh, no, not yet. And I said, ooh, depending on what that paper says, you may not be able to get a patent anywhere except the United States. And if you publish that paper more than a year ago, you probably won't be able to get it in the US either. So the key thing is file before you disclose. Now, what I'm saying, it's an enabling disclosure. If I say I've invented anti-gravity boots here in the public, I could go to Gillette Stadium in the middle of this, the AFC playoffs and say, I have anti-gravity boots, I've invented them. It's not an enabling disclosure because I didn't tell you how it works. So, but if I actually explain how it works enough that someone could figure it out, that's the problem. The other thing is the on-sale bar. The other part of if you've offered something for sale more than a year ago, then you can't get a patent in the US or any place. And so that gets tricky when you're doing things like experimental work. If you're going to go and disclose your stuff publicly, even test it, you want to check with it, and you think it's something that's worthwhile getting a patent, you want to check with a patent lawyer to make sure you don't trip over that on sale bar. In 2011, we had the America Invents Act. The US used to be a system where the first that the person who was entitled to patent was the first to invent. So if I could show that I invented before you did, as long as I filed an application, then I win. The famous case there was in the Bell telephone case against Gray back in the day of, which one invented first. We're now under a different regime like the rest of the world, which is the first inventor to file wins. So you can't sort of sit on it anymore like you could before. And this becomes a little tricky when you're doing joint development agreements. We're in the middle of negotiating one, and we'll try to be very clear in the agreement as to who has rights to which parts of the inventions, and agreeing, who can file first among the people that might be the inventors. Okay. Now, patents are expensive, as you're going to see. I'll give you some numbers. And you may not have a whole lot of money at first. So how do you file something without spending a lot of money? And it's called the provisional patent application. And because of that, this was provided so that the filing of the provisional application in the US is deemed accepted by other countries as being the equivalent of filing an application. So you don't get into that little problem of you disclose. You file a provisional and then you can disclose. I've seen people take a paper they're going to give at a conference, slap a covered page on it, and file it. And it's pretty cheap. Claims are not required in a provisional. The claims are the fence that provides what is protected. You don't have to have those in a provisional. Once you file a provisional, you have 12 months in which to get an actual application on file, a full application. So you could file a provisional and go out and start testing with customers and starting to disclose things selectively, and then say, oh, this has legs. I think maybe we ought to, or maybe we've attracted investment money and we can afford to file an application. So it gives you some time. Now the problem is the patent lawyers will say you really ought to put claims in it, you really ought to do this, and yeah, like you ought to do everything, but you can't. Can you afford everything? And the risk of a provisional is, if I in my provisional said, I've just discovered that fruits and vegetables are wonderful for health, and you should have 5 a day or something, and then in the course of the year, I say, oh, you know what? I should have included protein. Then I can't claim steak when I file the application because there's nothing that describes steak in the provisional. So the risk of a provisional is maybe you weren't broad enough. Now what we did when we were developing our IP Vision system is it was a SaaS system, so every 4 to 6 weeks we'd have a release. At the release time, we'd sit down and say, what did we do that we think is unique, useful, we ought to put a provisional patent application in? And every time we released, we would file appropriate applications. We might even file something if we said, we had this really good idea, but we weren't able to put it in this release. We'd file that, even though we hadn't actually done it. And then that gave us the time to experiment with it and see it was worthwhile. And it was pretty cheap at $70 to do that. Any questions on provisionals? Clear? A cheap way of getting there. Well, what you do is, the question is, what do you want to do if you want to add additional? Like in my steak case? Yeah, you'd file additional provisional. You don't have to wait for a year. Provisional gives you a filing date, and it doesn't actually get examined until you file called the utility patent. So it establishes a filing date, and since the first to file wins, you want the earliest filing date. So you'd file an additional application, unless you thought maybe your language in the provisional, it could be argued, encompassed, whatever the next edition was. So, yeah.
Do the provisionals become public information if you don't file?
They don't get published, so they're not public from that perspective. Way up back.
Quick question on if you're part of the MIT Accelerate program, do you recommend filing the provisional before you present?
Depends on what you present. you going to do an enabling disclosure? Right? Right? I push this button and, you know, things appear, and you know, unless you're saying, I'm offer to sell you this thing. There are exceptions in the academic world if it's not really public. Some arguments are around in classes. You know, that's not public. But you know, if it's something really valuable, I would check with somebody, you know, before you do it. There was a venture mentoring service client who was a professor at MIT, and he was interested in maybe launching a company around, it was an EECS type thing. And he had heard about this enabling disclosure thing, and he said, I did give a paper, and I guess I won't be able to get a patent. And I was talking to him and listening to the invention. I said, what'd you talk about in the paper? Oh, it was this and that. And it would be intuitively obvious, even to the most casual observer, what the next step would be. So I guess it's maybe an enabling disclosure, so I won't do the company. And I said, look, what you think is intuitive is not intuitive to one of ordinary means in the art. I would go talk to a patent lawyer and ask him very specifically to look into all the details. As a result of that, they decided it was okay, and it was worth the risk. They formed a company, and I think they ended up selling it for $250 million 3 or 4 years later. But he wouldn't have done it had he not, you know, talked to somebody about it. I did not get a commission. I should have. At VMS, we don't get compensated. It's all volunteer. We just get the satisfaction of being helpful. Okay, here's some of the costs. 15. So the first phase is, how much does it cost to get an application filed? You're in control of that pretty much. If you walk in with a lab notebook and throw it on the desk of the patent lawyer, it's going to cost a lot of money because he's got to read it and put it together. If you go and read some patents and get a feel for what they're like, and then you write something up that sort of follows what it is, describes what it is you've invented, why it's useful, then the lawyer's time is spent crafting the claims, which is the valuable part. And so you can control that. Once it gets filed, then it's the examiner and whether they object, and it's hard to keep that under control. But you could probably get a full patent application on for $5,000 or so. Although I've spent $30,000 once. One of my co-founders was talking to the patent lawyer, former MIT computer science professor, who should know better, started calling the patent lawyer directly, and I didn't know about it. And then I get a bill, like for $20,000. I said, what's this about? You're supposed to go through me. Oh, well, you know, your co-founder called me, and so I had to go have a yelling match with the co-founder. You come to me first, and then, because, you know, I've got to control how much time is spent on it. So you have to be, like anything, you got to manage it a little bit. This is the part that's tricky here. This is the key thing. If you do international, a government accounting office in a 2003 study looked at what it costs to obtain and maintain a patent in 10 industrialized nations. And over the life of the patent, including the filing, the translation in other countries, the maintenance fees, because you have to pay maintenance fees, it ranged, depending on the nature of the technology, because they're a little bit different in certain countries, anywhere from $300,000 to $500,000 to do that in 10 countries over the life of the patent. So they are expensive. So what do you do if you don't have that kind of money? Or put it another way, let's say I invented that vessel to hold a liquid, and you come along and you say, gosh, again, Joe, what a brilliant invention. Wish I'd done it. But you decide, I want to take that to market. What could you do if you were trying to economically, if you were going to try to make me license you on favorable terms? Remember, I have a right to keep you from putting my cup on any of your inventions. Can you think of anything? Okay, well, what What if you came along and said, I'm going to patent a handle, a lid, a styrofoam version of it, maybe a sleeve to go on it, all of the commercially useful things to implement it. And I'll have all of those there, and Joe, go ahead, try to go to market without anything useful. And that's called a picket fence. And a big company, could do that. They have the money to do that. So how do you beat that? Well, one way you do is if you think you can get a really strong patent on the core technology, and you have to figure that out with the patent lawyer who knows the stuff, and then you could go and you could disclose all those things. You could say, my invention is the cup, and it can be used with a lot of other inventions that I'm going to describe, but I'm not going to patent them. The handle, the top, and once you put it out there, it's in the public domain, and somebody else can't come along and then claim it. So it's like you have a castle and you burned all the brush out in front of it so the bad guys can't sneak up on you. That's cost effective if you can get a core patent. Okay, any questions? Okay. I'm going to talk just a moment about university licensing. You're here at MIT. Talk a little bit about the Technology Licensing Office. The background here is the federal government sponsors a lot of research. And under the research, they own the rights, the patent rights in the old days, and they were administered out of Washington. And only a very small percentage of the patents that came out of it were used by anybody because they were so far away from the inventors. So Bayh-Dole came along and said, you know what, we're gonna give the rights to patent and control those patents back to the institutions that we fund because they're closer to the inventors. And we're going to put some mandates around what they do. So any university that has any sort of major research funding has a technology licensing office. And this is the mission of the TLO here. They frame it in terms of not the maximum royalties they can get, but the mission of getting the technology out there in the world, which is an interesting way to talk about it because then you're not exactly held accountable for how much revenue you generated. By the way, does anyone know what I think the most, one of the most lucrative patent licensing agreements was? There are two of them. One is a product that you see at every football game. At the end of the game, when the winning team dumps Gatorade. Gatorade was patented. University of Florida made a ton of money licensing it out. The other was the Cohen-Boyer patent, which was the basic patents for gene splicing. Stanford made $250 million licensing that out. Now, the question is, does MIT own, just like when you work for a company, if you're at MIT, does MIT own anything? Well, if you make MIT's policy is if you make substantial use of MIT resources, MIT may claim ownership. So if you're doing experiments at the nuclear reactor, that's one extreme. If you're on Athena, using the word processing, that's not extensive use. If you're involved in sponsored research, that'll be controlled by the research agreement. You have to be a little careful who you collaborate with. The Media Lab, I think it's still this way, has a policy that all the sponsors get rights in the research in the lab. There's certain tiered aspects of it. And I had a client back in my law days who was an MIT professor in the AI before there was CSAIL. He had a grad student that was doing things both at the Media Lab and in the AI lab. And we got into a big tussle about did the sponsors of the Media Lab actually have rights in my client, the professor, who had nothing to do with the Media Lab except having a graduate student that spanned it. So we have to be a little bit careful about that. MIT can waive the rights to a patent if there's no sponsor rights, no significant use of MIT facilities, and no plan. So you can go and ask them, can you waive any rights you may have on this? Now, in addition, this all applied to federally funded research or things that, were done under contract at MIT. But recognizing that we have a lot of brain power around here, there are a lot of good ideas that are not just come up with. And so what the Technology Licensing Office did here was say, you can bring us those ideas, and we'll take over the patenting and licensing of those if they seem to be a useful thing to do. And that opened up the ability for professors to, just come up with ideas and send things over. And they can, if they accept it, they'll take over the patenting and the licensing operation with it. And then, I don't know if I put a slide in here on royalty sharing. I guess I didn't. Now, for startups, let's say you don't have the money to do a license agreement, but you want to use that technology, and you want to go to investors and attract them in. How do you do that? I don't have the money to get the license. Well, MIT will grant you an option for a license for very low fees, relatively low fees. Don't quote me on these fees. I haven't checked recently, but it used to be in that range. It's not a big number. And then you could confidently go to investors and say, I have an option to license this MIT technology on these terms, and here's my team, and here's my vision, and I'd like you to give me the gasoline called the money to make this thing run. And you sort of nailed everything down. And oh, by the way, MIT may take equity. So here's some example of typical license terms. If there's no equity, then there will be an issue fee when you actually get the full license. It could be $50,000 to $100,000 just to get the license. A maintenance fee paid to MIT of a percentage of the running royalty they get. There's a diligence requirement. You can't leave it on the shelf. You actually have to go forward with it. A royalty as a percentage of sales, anywhere from maybe 3 to 5%. I'm going to give you a royalty table in another slide here. The patent costs $25,000 to $200,000. So what MIT does is it goes out and gets a patent. If you license that technology, you have to pay MIT for the patenting costs as part of the license. So they sort of front the patenting costs. And you don't have to sponsor any research to get the license. If it's with equity, the thing that's different is the royalty is probably lower, and there's equity that MIT might get. This actually has turned out to be the most beneficial part to MIT of its licensing operation, is taking equity in companies. And that can be a win on both sides, because if MIT's holding the patent and has an equity interest in the company that's licensed it, and you're going to go and try to mess with that company and its patent rights, you've got MIT standing behind you. The typical startup equity terms are single-digit percentage of equity. It's maintained through whatever the business plan says you need in order to get to a commercialization point, or at least a Series A. They don't get diluted. They have that percentage at the first major financing. They have proportional anti-dilution thereafter, meaning once that financing has occurred, when the next financing happens, their percentage drops because more equity is being issued. It's proportional, yeah, meaning everyone gets diluted proportionally. And they have a right to participate in future financings if MIT's Treasury office wants to invest the endowment. Here are some typical royalties for university patents. It's probably about 10 years old. It's hard to get this information. But you can see it depends on the nature of the technology and the stage of development. So if you're at a clinical testing stage, it's a higher percentage royalty than if it's just a beginning type thing. And these change, markets change, but you get the idea of what it would be. There's an MIT royalty distribution policy. You can read about it in the materials. I'm not going to go into it here. Essentially, it's a third to the inventor, a third to the school or lab, and a third to MIT of the royalties after paying a bunch of the fees. So that's the sort of first stage, who owns the idea? How do you protect the idea? Make sure you have rights in this as you go out and try to start the company. Any questions at this point, beyond what we've talked about? Okay. How about legal entity? That's the next thing. Like I said, we could go into a whole evening just on legal entity, but the basic thing is if two or more people get together intending to do something for profit, you have what's called a general partnership. You don't have to have a writing, you just have to be doing that. And the problem with a general partnership is each partner is jointly and severally liable for any liability that the partnership may have. Jointly means if there are two of you, both of you are liable. And several means if I'm the one hurt, I can collect it from either one of you. So general partnerships are not a really great way to operate, especially if you're trying to raise money, because if I've got a bunch of money and I'm going to invest it into your partnership and something goes wrong, they can come after all of my money. And you're just an entrepreneur, a scrappy entrepreneur. You don't have any money. So investors don't want to invest in something where they can be liable for more than what they put in. Now, just on the basis of liability, make it clear, you're always liable for your own acts, right? So if somebody comes to me and he says, oh, I've invented this thing and I want to form a company so I'm not liable, a corporation. And the reality is if you have a defective invention, you're liable. Somebody comes and proves that you were negligent in your invention. But the practical matter is once you attract capital, they're not going to go after the inventor. But the basic point is you're always liable for your own actions. All right? So when we run through all of this, the basic thing you want to come up to is a corporation for most of the kind of things that probably come out of here, including people doing social developmental type things. There are different types of corporations. You mentioned a benefit corporation, again, to protect the people involved in financing it. Often it's a Delaware corporation because Delaware has a very advanced set of corporate laws, and so the predictability about what happens in this event or that event is better understood under Delaware law than under other law. California is getting pretty good, but especially if it's going to require lots of capital and very complex financing documents, Delaware law. Now, you should incorporate sooner rather than later if you've got a really good idea and you really think you're going to move, so you avoid that personal liability. And also, what we're going to talk about is Section 83. Before we do that, though, just incorporating doesn't solve the problem. You've got to actually, corporation, remember people, when Romney was in a debate and he said, corporations are people too, which is technically correct. They are persons under law. They can be sued and they can sue. And he was technically legally correct, but totally missed the whole point. When people are out there hurting and having 3 jobs and everything, thinking of corporations as people is sort of mismatched. It was weird. So, but in order to have the protection, you have to treat it as such. You have to have corporate formalities. You have to sign things in the corporate name and hold meetings and keep minutes and don't commingle your bank accounts and stuff like that. So, now, subchapter S. Corporations are formed state by state. You can form a corporation in any state. Subchapter S is of the tax code, federal tax code. Now, because corporations are people, are persons, the tax code, if you don't do anything, says, okay, you're a person, you owe taxes if you have profit. And oh, by the way, if you distribute that profit to shareholders, the shareholders get that and they're taxed, so there's a 2-layer of tax. Subchapter S says, no, we're going to ignore the corporation for tax purposes. Only 1 layer of tax, so that's good. You have to have, in order to qualify, you have to have less than 100 shareholders, only 1 class of stock, and all of the shareholders have to be human beings. In other words, they can't be like a venture capital fund. And they have to be either US citizens or permanent residents. So a French citizen living in Paris buys stock in your company, it can't be an S corporation. So some technical rules there if you can do it. And here's a question is, well, the typical thing, I'm going to raise money, I'm going to spend all this money developing stuff until I get a product ready. So I'm going to have losses. So why does it matter whether I'm an S corporation or not? I'm going to have losses. I'm not going to pay taxes. Well, it's because of the exit. When somebody buys the assets of the company, and these are the old tax, I didn't update this for the new tax laws, but the example here is if you're a C corporation, which is what happens if you don't do anything, there would be a corporate tax of, say, 35%, and then when distributed to the individuals, the effective tax rate combined would be like almost 61% of the profit earned. Where the S corp, no tax here, it's 39, 40%. So you could save 20% on an exit. Diva, which was one of the first companies that spun out, the first company that started out of the Media Lab, they said, oh, well, we're going to need venture capital, so we'll, we won't be able to do an S corp. I said, just humor me, do it. They never did raise venture capital, and at the end of the day, they saved about $1.5 million when they were sold. Again, I didn't get any compensation for that. Okay, now, the other reason to form a company, if you're going to form a corporation, to do it soon rather than later, is this very painful part of the tax code called Section 83. This is, you ought to pay attention to this. This is really important because it's going to hit you. It says if you receive property in connection with providing services, then you have ordinary income, which is taxed at a high rate. These are the old rates, not the new rates. It's equal to the fair market value of the property you received minus what you paid for it. Okay, so, and for this purpose, in a corporation, stock is property. With me so far? So let's say you come to me with a great idea, and I say, this is great. Let's set up a company and go for this. And to make the math easy, I'm going to put $1 million in, and I'm going to get 50% of the company. And let's say you think that's a fair deal, just again for math purposes. So, do I have tax? Do I have a problem? Well, the fair market value of the stock that you receive, because you're going to have 50% of the company, is either $500,000, right? Because I put $1 million in, and if we liquidated the company and we each own 50%, that's $500,000 each of the assets that are in there. So let's start with that. And what did you pay for it? Did you pay for the stock? You're the entrepreneur. So what's the ordinary income? And what's the tax owed? So thank you. Just write a check to the government for $200,000, and we're done. But we're not done. Who thinks that the value of what you got is more than $500,000? Why would I buy half the company for $1 million if the other half wasn't worth $1 million? So it could be that big. Not fun, right? And why did this happen? Because you receive, we're setting up a company, I'm putting my money in, and we're both getting our stock at the same time. And so we have an event that values the stock you got. It's kind of hard to say if I put $1 million in and got the same thing you did, that your thing isn't the same as mine. So the way around it is you incorporate as soon as you can, as soon as you're getting ready. It normally is going to take you many months to raise money, and you get your stock then. And then when I come along 3 months later, you already have your stock. And you heard the expression, ideas are a dime a dozen. Well, I could argue that your stock is whatever one idea is worth. So what's that, a penny or less? The problem is when you get your stock at the same time, as there's an event that values the stock. Okay, we clear on that? All right, so now, this happens, you want to separate the things in time. This thing comes up more often than you'd think, and it's because the founders don't actually get to have a discussion about how we're going to divide up the equity. And these are the reasons. Too busy, not sure who should get what. And let me give you an example of a technical founder and a business founder, right? And sometimes we don't want to have this discussion. So I have time, and I've got relative importance, and I've got a technical founder and a business founder. At t equals near 0, where on this relative importance graph would the technical person be? Be up there, right? If the thing doesn't work, we don't have anything. And oh, by the way, the business person really doesn't have much to do until the technology works. Okay. Now, over time, what's the relative in businesses? The relative importance of the technical goes down. The business starts low and goes up. Now, the slopes don't matter, it's the relative direction. On top of that, so that's part of what happens. And people have a hard time thinking about how much they should get, because now we're not going to have that discussion yet about who gets what stock, because we're uncomfortable discussion. But let's think about the dynamics of it. You're the technical person. It's your idea, your baby. You're working 80 hours, 100 hours a week to get the thing to work, right? And your co-founder is a business person who's probably got a day job and a side gig and all of that, and working on the business plan or connections or stuff. And you're going to say, well, what percentage of the company should I, as a technical person, get relative to that business person? Right? It's going to be, you're going to say, well, maybe I'll give the business person 5%, right? And so that creates tension. And maybe Yost will bring that out in his panel. I don't know the story of your people. But keeping this graph in mind is a way to have that discussion about what we're trying to do is we're trying to build something that has value down the road, big value down the road. And it's going to take both of our skill sets. And so we have to start with that understanding and then back it up to what we're going to get for equity. And then we'll talk a little bit more about equity next week in financing. So what happens is they never actually issue the stock, the money comes in, and then all of a sudden you got the 83B problem, the 83 problem. And yeah, you want to avoid this. There are things you can do, but if you incorporate early, I don't have to talk about the things you do after the fact. Okay, how about people? Bunch of issues you have to sort out up front. First of all, once you get together, you owe fiduciary duties to each other. There's a relationship formed there, especially small companies. So you're sort of, it's like a marriage. You're getting married as founders. You have to have, like, who's going to be on the board and what titles are people going to have and what functional roles. All that stuff has to get sorted out. And then stock. If we're going to be in this boat together, we better be in the boat rowing. And, if you want to try to sell your stock or you leave, we have to have a mechanism to keep that stock in the company until we get to some value point. So there's usually talking about restrictions on transfers. Like if you want to sell, can the company buy? That's one set of things. And there are a whole bunch of things, intramural disputes. And there's a memo on the website under the course materials called the Founders Memo, which I wrote many years ago after having 3 teams come in 1 week and having to spend 2 hours with each of them asking them questions that they hadn't even thought about asking themselves. So I went and wrote a memo that said, here are the things you need to think about before you go and talk about forming the company. So you can come in without spending a lot of time on lawyers' time, educated on your nickel, and then at least be able to understand what it's about. So read the Founders Memo. Equity split, we'll talk more about this the other night. I'm just looking at time here. I got to finish this up pretty much, don't I? We'll talk about equity splits. I'll come back on this next week when we look at Charlie's stuff. Typically at the beginning, if you're an early employee, you want to try to actually get the stock if the price is low enough, because anything after that will be capital gains. If you're going to get taxed on the value of the property versus what you pay and the stock price is high, you may not want to have to pay tax just to join a startup. And so what happens is you tend to get options. Options are the right to buy stock on certain conditions, and those aren't taxed when you get the option. It's only when you exercise them, depending on the type of option. So typical thing, if you're early on, get the stock until you can afford it, too expensive, and then you switch to options. So if you're a founder, that's what you'll do. Your early group will have stock, probably, if you're going to split stock up, and then the later people will probably get options. Yeah, this is all in the materials. It's about options. So the ISO, just terminology, so you're familiar with them. ISO, incentive stock options, are a special class of options. They're only available to employees. And they have certain benefits, which you'll see on the slide. Non-qualified stock options are to anyone, typically given to either consultants or board members who are not employees, and they have different tax consequences. But just so you're familiar with the terminology. Vesting. It's very typical on any of these equity grants to have the stock vest. So if I'm an investor and I come in and you presented me with a plan, and I say, oh, I like that plan, I'm going to put money in. When I write my check, I've done everything I said I would do. Oh, maybe I'm on the board and I help out and I give connections. I'm going to be helping. But essentially, that's the big part of what I've said I would do. You as the entrepreneur, on the other hand, you said you're going to do this plan, so you haven't done anything yet. And so investors want to know that you're going to be there executing that plan. And so the typical thing is to say, well, okay, I agree you have the stock there, but we're going to put restrictions on it. If you leave the company, then you're going to lose some of that or all of that stock. And the typical thing is 4-year vesting. In other words, if you leave before a year, you don't get anything. At a year, you get a quarter, and then it's usually monthly vesting thereafter over the next 3 years. And you probably want to, I recommend entrepreneurs and founders think about restricting the stock and putting vesting on it between them anyway, whether or not there's an investor on the horizon, because you want to make sure everyone's aligned. If somebody leaves, you want to get that stock back to be able to give it to somebody else to replace it. And if you don't do it, investors are going to make you do it. So put it in there and make it on good terms. Yeah.
With the founders, would you start the vesting from when you began working on the project? Or from when you formed the entity, or which point?
You could do anything. The question is, when would you start the vesting? So let's say you didn't actually issue stock. You get together and you're under the 100K and you're thinking about it and you're working on it, and then a year from now you say, we're ready, we're going to form the company. You might say, well, we've already worked on it a year, so we'll get 1 year vested right away. You could do that. Or you could say, we'll start right now. Chances are it may change who's on the team. So, behind her.
Yeah, I'm working on one right now where one of the people on the team had been working on it for a few years, and the others are coming in later, and so they have different rules.
Different ones recognizing the relative contribution. All this stuff, you have to assume with equity, and I'll come back on financing night to talk a little bit more about this. In any of the stuff involving rewards in a company, you have to assume everyone's going to know what everyone else has. So transparency, if you try to keep it hidden, it's not going to work very well. And maybe you've got some stories on that, I'm sure. Now we're about ready for the break. These are founder memos things. Probably when you go to outside funding, you might start to get an independent director, an outside team starts to form. And then we'll talk securities laws a little bit more in the essentially, if you offer or sell securities, you either have to register the whole thing with the SEC, which is very expensive, or you have to find an exemption. So if you're going out to start to raise money, make sure you talk to a lawyer who understands how to make sure you do it right. Otherwise, the investors can get all their money back from you if you screwed it up. It's not a good thing. And please don't put in a pitch deck, we're offering X% of the company for Y dollars. First of all, that's an offer for securities law purposes, so you've just violated the securities laws. And secondly, the investors are going to have a discussion with you about what the value is, and you're going to come to negotiations. So it's a little presumptuous unless you're, Bill Gates forming a new company to put the terms out right there. It's a discussion you have. It's a process. So, but you see this all the time. And it usually, the message to investors are, these people aren't sophisticated. First of all, this is a ridiculous valuation given for this project in this industry in this time and space. Maintain some credibility. Crowdfunding is relatively new. And there's a question on any time you take an investor in, again, on financing night next week, we'll go into more. They're with you for a while, and they can affect, the nature of your first investors can affect your ability to raise additional money later. And you have to think that through very carefully. So I think we should do a break now. Are your people here? Okay. Good. You want a 10-minute break? 10-minute break? And I'll be around to answer questions later. I'll be back next week on the financing thing. We'll go into a little bit more of the stuff around the instruments used for it. Okay? By the way, good video, good short video to look at.